Welcome, everyone. My name is Flaminia Stârc-Meclejan. I'm an associate professor of the West University of Timișoara, the Faculty of Law. And I'm going to present a paper on when corporate law meets the platform economy. It's like Uber, Airbnb, Amazon go beyond technological intermediaries nowadays. They do not simply connect users through technology. In reality, they organize and structure entire markets. They shape behavior, regulate contracts, and control markets. So that platform influence how users act through algorithms, ratings, pricing systems, and visibility rankings. Effects extend to labor, taxation, and social norms. This creates challenges for tax systems. They also influence social behaviors and redefine employment relationships. Platforms often operate across borders beyond traditional legal reach. Digital platforms function globally while legal systems remain primarily national. This creates regulatory gaps and enforcement difficulties. Traditional corporate law fictions are, as you for sure know, legal personality, which sees company as a separate legal entity, asset separation that looks at company assets as separate from shareholders' assets, limited liability that encourages investment by limiting personal risk, and corporate autonomy, whereby decisions made by internal organs are made by internal organs like board and general assembly. The purpose of corporate law fictions are to facilitate economic activity in complex markets, as corporate law creates a structured legal framework that allows businesses to operate efficiently in large and complex markets, to protect investors and mobilize capital. Through limited liability, investors are protected from losing more than the amount they invested, to enable companies to enter contracts on property and bear obligations independently, as legal personality allows the company to act as a separate subject of law, and to promote predictability and stability in commercial relations, since corporate law establishes clear governance structures, decision-making rules, and accountability mechanisms. This predictability builds trust among investors, employees, creditors, and business partners. Corporate law fictions, however, assume alignment between legal form and actual business. The registered office, corporate governance structure, and declared activities are expected to correspond to real economic activity. It works indeed if the company has clear location, hierarchy, and assets. In this model, legal personality and limited liability function effectively because responsibility and control are clearly traceable. But the functions fail when entities operate virtually. They are decentralized and opaque. Digital platforms often operate across multiple jurisdictions simultaneously, rely on algorithms instead of traditional managerial decisions, use complex corporate structures to distribute risk, and lack a clear physical center of economic activity. So platforms rather act as ecosystems, not simple companies. Digital platforms do not function like traditional firms that produce and sell goods or services directly. Instead, they create and manage a digital environment where multiple actors interact. Users create value, platforms organize and control it. Unlike traditional companies, platforms often do not produce the core values themselves. For example, drivers create value on ride-hailing platforms, hosts create value on accommodation platforms, sellers generate value on online marketplaces. However, the platform controls access to the market, sets the rules of participation, determines visibility through algorithms, collects and processes data. For example, social networks are Facebook and Instagram, marketplaces are like Amazon and eBay, and crowdsourcings like Upwork and Kickstarter. So platforms define access pricing and user rules, prioritize or exclude content automatically, collect or exploit user data, and operate via algorithms, automated decision making, and opaque processes. There are also legal challenges. No clear distinction between users, collaborators, and consumers. It is difficult to define responsibility, rights, and accountability. The virtual headquarters complicate jurisdiction and taxation. Organizations may span multiple territories without a physical presence. Activities often partially hidden for regulators. Enforcement gaps and compliance challenges so rise, and existing laws cannot fully capture digital realities. So digital ecosystems require innovation, governance, adaptable legal frameworks, and transparency mechanisms to address these challenges. There are some CJEU cases in which the court render judgment as to the legal regime of such platforms. And we shall first look at Uber, where the court decided that Uber is not just an information service, but acts as active transport service provider, controls pricing, driver selection, and service quality. So it is subject to national transport regulations, not only to the e-commerce law. There in Airbnb, the court decided that Airbnb provides information service less direct control, so platforms may still qualify for e-commerce protections, and there is need for a case-by-case analysis to see the level of active intervention. And in your Dell case, the court decided that it addresses independent contractors versus employees. Autonomy does not automatically exclude economic dependency, so courts must assess actual relationship to determine legal status. What are the legal implications of these cases? That platforms are to be treated as active economic agents also, subject to consumer protection, IP law, and labor standards. And there is loss of prior intermediary immunity and new legal and economic obligations. What was the EU regulatory response? There's been adopted the Digital Services Act that modernizes rules for online platforms, the Digital Markets Act that addresses gatekeepers platforms, the Digital Services Act being a risk-based approach for setting up obligation scales with platform size. What are the main obligations established by the Digital Services Act? Transparency and content moderation reporting, mechanism to contest removal or labeling of content, enhanced supervision for very large platforms, and cooperation with national authorities. Another instrument to deal with the new challenges posed by platforms is AI and algorithmic responsibility. AI decisions influence corporate and social outcomes. Automated systems now make important decisions in hiring and recruitment, the credit scoring and finance, pricing, logistics and supply chain management, content moderation, and online platforms. These decisions can affect people's rights, company profits, and market fairness. What are the key requirements for responsible AI? Traceability, ability to track how the AI reached a decision, transparency, clear explanation of what the AI does and why, and human oversight. Human must monitor AI decisions and correct errors. And last but not least, EU artificial intelligence focuses on high-risk AI systems that can seriously impact people or markets. They require developers and companies to document AI decision-making processes, test and audit AI systems regularly, ensure accountability and compliance with EU law. Why it matters? Because it protects the users, employees, and society as a whole. It holds companies accountable for AI-driven actions, reduces risk of bias, discrimination, and economic harm. Then there is the solution of legal personality for autonomous digital entities. Some scholars propose giving legal personalities to autonomous digital entities. Of course, this is controversial because they do not have human will or intent, do not hold assets or have offices in the traditional sense, cannot be held responsible in the usual way. So possible solutions would rather be a custodian model, a human or corporate operator that acts as the legal owner and assumes responsibility, a liability framework, the platform or development can be held accountable for autonomous actions, which ensures responsibility is assigned, preventing thus algorithmic impunity. There's also another solution of corporate governance adapted to digital risks. Because traditional boards must evolve to oversight of AI and algorithms. Boards need to understand how automated systems affect users and markets, set ethical standards, establish rules for data use, privacy and fairness, cybersecurity preparedness, protect platforms and users from attacks. The implementation supposes creating a digital risk committee reporting directly to the board. It requires members with technical expertise in AI and data governance and links executive incentives to responsible digital governance. Towards a responsible digital economy, indeed, digital platforms challenge classical corporate law fictions like limited liability and legal personality. Solutions include, as I said before, aligning legal responsibility with economic reality. Platforms with control over transactions, content, or workers must assume liability. Regulatory frameworks like the Digital Services Act or Digital Markets Act that ensure transparency, fair competition, and user protection, and apply stricter rules to very large platforms with systemic influence. A governance adaptation board oversee digital risk, AI ethics, and cybersecurity. And policies must integrate algorithmic